So, welcome everyone, distinguished guests, participants, colleagues, and students. On behalf of the School of Law of Euclid Cyprus, it's a real pleasure for me to welcome you all this evening to this webinar in memory of the late His Honor Judge Roger Elsey, resident judge of the Sovereign Base Areas from March 2019 until his unexpected death in October 2021. I would like to warmly thank our distinguished guests and speakers, both from the Judiciary of England and Wales and of the Republic of Cyprus, as well as from academia, for their willingness and enthusiasm to speak to us tonight. I would also like to thank all participants coming from so many different backgrounds and professions, as well as Roger's family and his peers for their support. It's a real pleasure and honor to be able to engage with so many of you all gathered tonight to pay tribute to a wise man who is dearly missed both within and beyond the judiciary. Before I continue, please be reminded that this webinar is recorded for the purposes of widening access to educational resources and that you have been asked to consent to this. I would please ask you all to keep your cameras and microphones off and to use the chat function in the MS Teams classroom to ask questions or make comments. If you do not wish to appear at all on the recordings, do not use the chat function either. Can I please also remind all that each speaker and other participants will take part for educational purposes in an educational setting. Accordingly, what each participant will provide verbally, electronically, or otherwise must not be accepted or interpreted as either legal advice or any form of advice. You may view materials at your disposal in the MS Teams classroom, which you are free to take away from this webinar and use this with necessary acknowledgements. Subject to the professional background of each of you, each attendee, participation may contribute to your formal or informal continuous professional development, or CPD, or professional development, PD, or other self-managed learning and development needs. Cyprus registered lawyers have been asked to provide their registration numbers so that we may report their CPD hours for this webinar onto the Cyprus Bar Association platform. It is necessary, however, to attend most of the webinar to collect the hours. Let me now turn to the subject matter of tonight's webinar and explain the title of the webinar. When asked last week by a journalist on a local radio station here in Cyprus why we had titled the webinar Judicial Leadership and the Rule of Law to pay tribute to Judge Roger Elsey, there was clearly a lot to say. But if there is one thing which I think best illustrates the relationship between the title of tonight's webinar and Judge Roger Elsey, it is the best example he was setting in all instances, both inside and outside his courtroom, participating to legal education both formally and informally. Judge Elsey was both very approachable, while at the same time upholding the rule of law and the highest ethical standards in the judiciary and more widely in his life. It was a true honor to have met him for all of us here at Euclid Cyprus. Of his life, we can say very briefly that Judge Elsey was educated at Newcastle University and having joined Gray's Inn, was called to the Bar of England and Wales in 1977. In the years that followed, he practiced as a barrister before embarking upon a career as a member of the Judiciary of England and Wales, primarily based in the northeast of England. He became a deputy district judge in the Magistrates Court in 1999, a district judge in the Magistrates Court again in 2004, and the resident judge, as well as Her Majesty's coroner of the sovereign base areas of Akrotiri, Dekeli, and the island of Cyprus in 2019. In that latter role, Judge Elsey made a significant contribution to the education of students, including those reading law at the Cyprus campus of the University of Central Lancashire. of Jutland, Cyprus. And here we are tonight. In fact, continuing the existing tradition set by his predecessors on this island to engage with the wider community, including students, staff, and alumni at local universities. Judge Elsey got in touch as soon as he set foot on the island of Cyprus in 2019 and offered his time, knowledge, and function to the school. This took the form of regular visits to the campus. I remember Roger on campus one day prior to the first lockdown of March 2020, delivering a guest lecture to the students on legal skills. He was indeed the last visitor at university before the big unknown created by the initial phase of the pandemic kicked in. Roger also made time to welcome law students to his courtroom, both during and post-trial, and spend time with them to explain the particular proceedings. As we will hear later tonight, his social life on the island was also an example of judicial leadership, as well as his participation to events organized by the School of Law, where he would contribute with his usual modesty. I have in mind a particular webinar on transparency and open justice in March 2021, supported by the British High Commission in Nicosia, where he gave us some insights of the work of the SBA's courts, as well as the Ethics Day on campus, painted here in this picture, where you can see quite a few of us and you can see the diversity of the people he was engaging with, from retired top judges of the Republic of Cyprus to academics, PhD students, and the wider society. Today marks exactly 1 year since Roger last visited the campus in person on the 29th of June 2021, together with the Honorable Judge Michel Brewer, on a mission that was close to his heart: how to raise awareness and help victims of human trafficking in Cyprus. We will be grateful to Roger forever for facilitating access to knowledge and expertise in the field, and for inspiring us for what has now become one of the flagship research projects of the School of Law on smuggling and human trafficking across the Green Line, supported again by the British High Commission in Cyprus. All events related to this project are held in particular conditions following his unexpected passing away, marking every single time a moment of silence. Against this background, academics and students at the School of Law of Jutland, Cyprus promptly resolved to honor his memory in an appropriate way. The outcome of this resolution is tonight's webinar, which would not have been possible without the valuable support of his family, of members of the Judiciary of England and Wales, but also of the sovereign-based areas, the British High Commission in Nicosia, and the Judiciary of the Republic of Cyprus, to all of whom the school extends its sincere thanks. I would now like to invite to the virtual floor the Honourable Mr. Justice Mark Bishop, presiding senior judge, sovereign-based areas of Akrotiri and Degelia, to deliver the keynote tonight in the absence of the Honourable Mrs. Justice Chima Grab, DBE, Judge of the Queen's Bench Division of the High Court of England and Wales, and lead presider on the London and South East Circuit, who unfortunately is unavailable tonight. So I am going to stop sharing my screen and I am going to call to the floor Mr. Justice Mark Bishop, if you can hear me. Thank you very much.
I can hear you, Stephanie. I hope everybody can see me and hear me. I have no slides to put up, so I'm afraid it's just my picture, I'm afraid. But we're going to, I hope a lack of slides will not put you off. So, ladies and gentlemen, it's a great honour to have been asked to deliver this lecture on judicial leadership and the rule of law. albeit in circumstances where we greatly regret that Mrs. Justice Chima Grubb is unable to be present. I know how disappointed she will be that she is unable to deliver a lecture on this occasion today. This is a subject about which I know that she feels passionately. I'm honoured to be asked to step into the breach, but I'm also honoured to speak at this occasion, which is to celebrate the judicial work and leadership of Roger Elsey, resident judge in the SBA until his untimely death last year. I knew Roger from just after the time of his appointment, when I had just been appointed to my current role, and as we got to know each other, embarking on these new roles, a very good friendship developed. Upon meeting Roger for the first time, it was immediately clear to me that an outstanding appointment had been made, and the Sovereign Base Area were very lucky to have him as their resident judge. And I'm delighted that Sue, Elsey, and the family are all on this webinar, and it's very good to be brought together in this way. Now, as we've already heard from Stephanie, Roger had enjoyed a distinguished legal career at the bar and as a district judge before his appointment here in 2019. Practiced at the bar in Newcastle, became a district judge in Teesside Magistrates Court, and then was the designated judge for the North East in the Magistrates Courts. And over the following years, he was authorised to sit in every aspect of Magistrates Court work, including being authorised by the Lord Chief Justice in 2018 to sit in applications under the Terrorism Act. And I think it is, as I've commented on other occasions, it is worthy to note, I think, that only a few district judges in the United Kingdom are authorised to sit in terrorist cases, and Roger was one of them. Now, these are the bald facts of his legal career, but of course, to be a good judge, and Roger was a very good judge, you must bring wisdom and good judgment to your work with a keen sense of fairness and empathy to your fellow man and woman. And Roger had those qualities in abundance. And it is therefore a great privilege to speak on this occasion. So, to judicial leadership and the rule of law. Judges have not always had a very good press from our greatest writers. You will remember the opening chapter of Bleak House by Charles Dickens, which begins with a description of implacable November weather in London, where there is mud in the streets and fog everywhere. But Dickens writes, "Never can there come fog too thick, never can there come mud and mire too deep, to assort with the groping and floundering condition of the High Court of Chancery." And he goes on such an afternoon, the Lord High Chancellor ought to be sitting here with a foggy glory round his head, softly fenced with crimson cloth and curtains, addressed by a large advocate in whiskers, an interminable brief, and outwardly directing his attention to the lantern on the roof, where he can see nothing but fog. Well, the interminable and never-ending case was, of course, Jarndyce and Jarndyce, where justice was never achieved, as the law and the lawyers were engaged in their own closed world without reference to the wider world outside. And their consequence of their foggy lack of progress in reaching a just result caused Charles Dickens to write this warning about going to court. "Suffer any wrong that can be done you," he said, "rather than to come here." Now, I think that any lawyer, and particularly any judge, should read Bleak House. It should be compulsory reading. Because what is described there is a legal system and a judiciary that is unconnected with the world in which it is set, and which is inward-looking and completely unaware of the consequences of its inactivity and inefficiency for litigants and the wider society. Dickens had been a law clerk before he was an author, and his insights into the mid-Victorian English legal system before the reforms of the 1870s show us how things can go wrong for a legal system. However, for an example of judicial leadership, I think we need look no further than to Lord Atkin and his great dissenting judgment in Liversedge and Anderson in 1942, Appeal Cases 406. You'll remember the facts. It was World War II, and the Home Secretary had a power to intern people if he had a reasonable cause to believe that they had hostile associations. And he exercised his powers in respect of Robert Liversedge, committing him to prison, but giving no reason. On appeal, the courts had to decide to what extent, if at all, judges could investigate the objective basis for the Home Secretary's belief that he had a reasonable cause. The majority of the House of Lords held that as long as the Home Secretary asserted that he had such a reasonable belief and was acting in good faith, then the statutory requirement was met. However, in Lord Atkin's dissenting judgment, he said that the majority had abdicated their responsibility to investigate and control the executive and were being, in his words, more executive-minded than the executive. Lord Atkin protested that his fellow judges were putting a strained construction on words with the effect of giving an uncontrolled power of imprisonment to the minister. And Lord Atkin went on to make this profound statement concerning judicial leadership and the rule of law. In England, he said, amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty for which, on recent authority, we are now fighting, that the judges are no respecters of persons and stand between the subject and any attempted encroachments on his liberty by the executive, alert to see that any coercive action is justified in law. And in this case, Lord Atkin said, I have listened to arguments which might reasonably have been addressed acceptably to the Court of King's Bench in the time of Charles I. And he went on to refer to the exchange between Humpty Dumpty and Alice in Wonderland, saying that their exchange was the only authority for what was being contended for before him in the House of Lords. Lord Atkin quoted from Alice in Wonderland in his judgment. When I use a word, Humpty Dumpty said in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. The question is, said Humpty Dumpty, which is to be the master? That's all. And so Lord Atkin concluded that after this long discussion, the question is whether the words, if a man has reasonable cause to believe, can mean if a man thinks he has reasonable cause to believe. And he says, I have an opinion that they cannot, and the case should be decided accordingly. Now, Lord Atkin came under great pressure to change his judgment in the midst of war. It was argued in 1941, at the darkest time of the war, and the judgment was given in 1942, when things weren't significantly better. And I think it's an exceptional example of judicial courage and leadership. He did not change his judgment. He was not prepared to agree to put a strained construction on words with the effect of giving an uncontrolled power to the Home Secretary. He stood out against the unjustified encroachment of the state into the freedom of the citizen, even in times of war. And as time has gone on, this great dissenting judgment has been recognized as authoritative, and the views of the majority are wrong. Well, I think the example of what happened in the judgments of the House of Lords in Liversedge and Anderson illustrate that the rule of law is not to be understood as simply what the majority in the Supreme Court or the House of Lords have held to be the law at any particular time. Nor can the rule of law simply be what statute enacts. The rule of law is based on a more fundamental set of truths. So what does the rule of law mean? Well, politicians often speak of upholding the rule of law, and lawyers speak of it as a core principle. But what is its essential quality? In the United Kingdom in 2005, the Constitutional Reform Act reformed the role of the Lord Chancellor, and at Section 1 it said that nothing within the Act adversely affects the existing constitutional principle of the rule of law, nor the Lord Chancellor's existing constitutional role in relation to that principle. In his oath of office, the Lord Chancellor swears to respect the rule of law. However, the Act never defines what the principle of the rule of law means. Now, Lord Bingham, a modern judge who demonstrated great leadership in support of the rule of law, discussed this lacuna in the legislation and went on to deliver his analysis in his seminal Sir David Williams lecture in 2006. And I know that work is being done in this university on the operation of the rule of law, drawing on his work in this field. The core of the rule of law, according to Lord Bingham, was that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws, publicly and prospectively promulgated and publicly administered by the courts. And he relied upon Thomas Paine's great declaration that in free countries, the law ought to be king, and there ought to be no other. And Lord Bingham identified 8 conditions of a society which, if present, demonstrated the presence of the rule of law. I'm sure we're all familiar with them, but I will set them out again and accompany them with some brief thoughts on their operation from my perspective as a working judge. The first principle was that the law must be accessible and, as far as possible, intelligible, clear, and predictable. Jeremy Bentham, writing at the end of the 18th century, criticized customary law in general and common law in particular for failing to satisfy this requirement. He considered that the sources of law were hidden in obscurity, and though there were spurious appeals to precedent, much of the law was just made up by the judges as they went along. Now, it's surely true that if judges are unable to express their findings clearly and succinctly, or if legislatures become hyperactive in generating an abundance of laws, which are difficult to understand or follow, then the rule of law is undermined and diminished. I am a criminal judge in the United Kingdom, where Parliament seems particularly interested to pass frequent legislation, both primary and secondary, of great complexity, dealing with sentencing reform. These changes have a profound effect on people's lives, but the frequency of legislative change means that at times legislative coherence can be lost and the law becomes inaccessible. Professional lawyers must be able to advise on what the law is and what the likely outcome of a legal adjudication will be. The second principle Lord Bingham set out was that disputes must generally be resolved by the application of law rather than the exercise of discretion. In a modern system of administrative law, the possibility of the exercise of a discretion by public officials outside a policy must be possible. But that discretion must be properly framed and authorized, and the application of rules and judicial procedures must be preserved for those cases where liberty and well-being are most seriously at stake. The development of judicial review in the United Kingdom over the last 50 years or so has been a striking development of the common law, which has provided constitutional supervision of public authorities. Lord Diplock in 1982 described the development of judicial review when really it had only just begun. as having been the greatest achievement of the English courts in his judicial lifetime. That's the Crown against IRC ex-party National Federation of Self-Employed and Small Businesses in 1982. And Lord Gough in Kleinmort Benson against Lincoln City Council in 1999 referred to the developments of judicial review in English courts as radical judicial developments, which through decisions of the courts in the middle of the century had led to the creation of our modern system of judicial review. I think that Lord Mustill, in the Fire Brigade Union case in 1995, carefully explained the scope of judicial review and the delicate balance in play between judges, the executive, and Parliament. He said this: the courts interpret the laws and see that they are obeyed. This requires the courts on occasion to step into territory that belongs to the executive, to verify not only that the powers asserted accord with the substantive law created by Parliament, but also that the manner in which they are exercised conforms with the standards of fairness which Parliament must have intended. To avoid a vacuum, he says, in which the citizen will be left without protection against a misuse of executive powers, the courts have had no option but to occupy the dead ground. Absent a written constitution, much sensitivity is required of the parliamentarian, the administrator, and the judge if the delicate balance of the unwritten rules evolved is not to be disturbed and all recent advances undone. So cautious words from Lord Mustill some 25 years ago. The heart of the judicial review jurisdiction is to ensure that public bodies respect the rule of law. The third principle set out by Lord Bingham is that the law must apply to all. And this means, of course, that there can be no distinction between citizens of the country within the jurisdiction and others. A state cannot pick and choose the people to whom the law applies. And that is a principle that has been vindicated in legal cases that arose post 9/11 in respect of Guantanamo Bay in the United States and the detention orders legislation in the United Kingdom. And in the latter case, Lord Bingham held that the UK legislation was incompatible with the European Convention on Human Rights and was disproportionate by permitting the detention of suspected international terrorists in a way that discriminated on the ground of nationality or immigration status. His fourth principle was that the law must protect fundamental human rights. Well, a state which, even through a democratically elected parliament, passed a statute which forced the exposure of female children on the bare mountainside, to use Lord Bingham's example, could not be a state which was observing the rule of law, notwithstanding its compliance with the statute enforcing such a grotesque policy. Now, in the United Kingdom, judges of the High Court and above, and equivalent judges in Scotland and Northern Ireland, may issue a declaration of incompatibility to the European Convention on Human Rights when considering legislation. And this means that Parliament then has the opportunity to change the law to bring it into compliance with the ECHR. And this, importantly, recognises the constitutional doctrine of the sovereignty of Parliament. And there is also a fast-track procedure to achieve compliance through the use of secondary legislation, although this has been rarely used. Now, the number of declarations of incompatibility have been small in comparison to the number of challenges. However, Section 3 of the Human Rights Act requires that all judges at all levels in the judicial system, insofar as this is possible, must give effect to all primary and secondary legislation so as to be compatible with convention rights. And this is the course that is often adopted by the courts when such an issue arises. The fifth principle is that disputes must be resolved without prohibitive costs or inordinate delays. Well, access to legal aid is an essential feature of any legal system that operates within the rule of law. And as every common lawyer should know, justice delayed is justice denied. For those of us in the criminal courts, the exercise of case management powers in setting timetables and ensuring that the real issues in the litigation are set out well before the trial so that resources are directed at essential topics and not peripheral issues has been an important part of our experience of a modern criminal justice system. Interminable delays before trial are unacceptable and they undermine the rule of law. And this, of course, has been the pernicious effect of the COVID period over the last 2 years, because it's added to the delays before trial, with adverse effects on the engagement of witnesses and complainants in the process. And this undermines the efficacy of the criminal justice system, and confidence in the operation of the rule of law is diminished. His sixth principle was that public officials must use their powers reasonably and not exceed their powers. Well, this means that the rule of law requires independent judges who have the power to rule against the decision of ministers and public officials carrying out a government policy. The whole process for the appointment of judges must be independent of the executive. Now, in the UK, we now have a Judicial Appointments Commission, which is independent of the executive and runs competitions for new judges, and after interviews, draws up a list of those who are suitable for appointment. Now, of grave concern for the operation of the rule of law is any attempt by an executive to manipulate the appointment of people as judges who are seen to be loyal to the wishes of a particular government minister or ruling party. Striking at the independence of the judiciary in this way is to undermine the rule of law, because it brings into question the independence of the judge being required to adjudicate upon the exercise of powers by public officials. The seventh principle is that the system for resolving differences must be fair. The adjudicative procedures provided by the state should be fair to all parties, obviously. With the increased use of remote hearings in recent years, with advocates and defendants appearing over live links of various kinds during the recent pandemic, the Coronavirus Act 2020, which was our statute that brought in many changes at the beginning of the pandemic, that act emphasized the need for all participating in such hearings to be able to both see and hear each other at all times during the hearing. And if they cannot, then the hearing is unlawful. Now, I've always understood that to be a practical requirement, but it is underpinned by our commitment to the rule of law, that notwithstanding these aids to communication, the fundamental requirement that all people must be able to fully participate in the hearing is sacrosanct, and without it, the process ceases to be fair to all parties. Full participation requires being able to see and hear everyone participating, whilst at the same time being seen and heard by the other participants. And finally, his eighth principle was that a state must comply with its international law obligations. Well, it is, I hope, inconceivable that a state which respected the rule of law could embark upon an action which it knew to be unlawful. Well, ladies and gentlemen, in conclusion, Lord Bingham said in his 2006 lecture that judges are not, as we are sometimes seen, mere custodians of a body of arid prescriptive rules, but are, with others, the guardians of an all but sacred flame, which animates and enlightens the society in which we live. Well, I am delighted that as lawyers and judges operating in our respective courts and jurisdictions, we are able to share in the guardianship of this flame and reflect together on these great principles which are so important to the sustenance of a peaceful, democratic, rules-based world. I'd like to end this lecture by commending this university and the Department of Law, which has organized this webinar. It seems to me that you are uniquely placed to be a forum where these principles are articulated and discussed, being at the crossroads of 3 continents, which are all places which need these principles as never before. And I think you bring particular insights as well into these issues through your physical location in this part of Cyprus, which lives with the continuing consequences of conflict. And I wish you well in the impressive research and project work in which this department is engaged. Thank you.
Thank you so much, Mr. Justice Bishop, for a very enlightening keynote, despite, obviously the circumstances. So we're very grateful, very much grateful. I have to say, I think that you have raised a number of very interesting issues, and I'm sure they will come back to the fore in the second part of this webinar. So thank you once again. Now, we have welcomed, while we were listening to the keynote, quite a few more people. Welcome, everyone. Apologies if there were some issues, technical issues. Unfortunately, these are unavoidable. And thank you to all colleagues who are helping participants to join. Now, could we please turn to the next speech in the series, and we are very happy to welcome to the floor. So basically, we will change a little bit the program since we have heard Mr. Justice Bishop quite a lot. So we have decided that, we are going to skip what he was going to talk about. And we can come back to it at the Q&A session, of course. And we are going to welcome straight ahead the following speaker, who is the Honorable Judge Michelle Brewer, Judge of the First Tier Tribunal, Immigration and Asylum Chamber at Her Majesty's Courts and Tribunal Service. And Judge Brewer is going to talk about His Honor Judge Roger Elsey's commitment to pastoral support, which is of great importance, of course, to academics and the wider society, which we have already spoken about quite a lot. So, Michelle, the floor is yours. Thank you very much. I can't see you, but I suspect.
Can you see me? I've got my camera on, so I'm slightly worried if you can't see me, Stephanie.
I can't see you, Michelle, but it may just be me. Can anyone see Judge Brewer?
My camera should be on. Can you hear me?
We can hear you very well, yes, but we can't see you, unfortunately.
I don't know why my camera's not working. Is everyone fine for me just to speak, even if you can't see me? Because rather than me fiddling around with my settings, because my camera does seem to be on.
Yes, of course, we are very fine with this, of course. Thank you.
Thank you. I'm sorry that you can't see me. It's a classic tech that's now happening and the new ways of working. But Galisperas, everyone who is joining us from Cyprus, and good afternoon to friends and colleagues from the UK. My talk this afternoon is very much going to be a personal talk, looking at very much my interactions with Roger and what I think were really the key traits that he displayed as a leadership judge. As we know, this webinar is about honouring the memory of Roger, who was a dear and treasured friend and colleague to many of us here. I felt very privileged to be invited to speak at this event. However, I was also very conscious that there are many here who have joined this webinar and who are listening, who have known and worked with Roger for a very long time. And I had not done so. I had, in fact, only met Roger as a very newly appointed judge. I was only about a year into my judicial career when I met Roger early last year. And we met and began working together because of our shared interests in how we as judges respond to the global problem of human trafficking. So it really was only for a short period of time, but for me, certainly it was a very significant, he had a very significant impact, not just on my work around human trafficking, but my introduction to the judicial community that I had joined. And so this afternoon, I really want to reflect on how Roger's generosity and guidance to me as a newly appointed judge really helped me find my feet in my new judicial community. And whilst reflecting on that, there are always people when we go through life who stand out as our teachers, our mentors, our stalwart supporters, those people whose guidance resonates and reverberates throughout our career. And to me, Roger very much embodied all that was good in pastoral care and collegiality. And he was someone certainly I know going forward in my judicial career that his guidance and his support will always stay with me. When Roger and I met last year, as I said, I'd only been a judge for 1 year and I hadn't actually held a judicial post ever before that. Roger, on the other hand, as Mr. Justice Mark Bishop said, had started his judicial career back in 1999, the same year that I was called to the bar. And he invited me out to the SBAs as the resident judge there. And for a week, we travelled around the island meeting and discussing human trafficking with our Cypriot judicial colleagues and speaking to those very much at the coalface of working with victims of human trafficking. We're also very privileged to be invited by UCLAN and Stephanie and her team to be part of an expert roundtable on trafficking in human beings. When I had accepted the invitation from Roger to come out to Cyprus, I wasn't really sure what to expect. Roger, for me, was very much someone in the senior judiciary, up in the hierarchy. I was a newly appointed judge. We both sat in very different jurisdictions. I was a tribunal judge and he a court judge. So I was really not sure about what that dynamic would be, particularly in our discussions and interactions. But it'll come of no surprise to those who knew Roger very well that I had nothing at all to worry about. By the time our week was over, having travelled around the island in his car that had no air conditioning and 40 degrees heat, I very much had found a new friend in Roger. And again, reflecting on what I was going to draw out today, I was trying to tease out what exactly it was that Roger did over that week and with ongoing contact after that really cemented in my mind that I had found both a friend and an ally, but someone who also epitomised what won all that is best in judicial leadership. And really, the one thing that stood out for me was Roger's ability to actively listen and engage. He was someone that very much had this innate ability to value what was being said to him, irrespective of who was speaking, irrespective of where they sat in the hierarchy, irrespective of gender, race. He very much was someone that just listened and engaged. I recently wrote an internal article for our Diversity and Inclusion Task Force within the Tribunal, which I'm a member of. And I thought about and I wrote about active listening as a necessary skill for our leadership judges. And when I was writing this piece, Roger was very much at the forefront of my mind as someone who typified this. And the discussion was around the 4 levels of active listening, but particularly the highest level. And that's what really I think Roger held. And that was the ability to empathetically listen, but not just listen, but at the same time consciously think about how to tap into the potential of the person they're listening to, how to help that person reach their highest future possibilities. And that's something that Roger did unconsciously, and certainly something that I felt he supported me in when we began working together. And I cannot overstate the impact that that will have and can have on individuals. As someone who, and I don't particularly like this term, but as someone who came from very much a non-traditional background, as someone who grew up with a teenage mother on a council estate in Fife, she was on benefits. Roger, having someone like Roger in your corner, someone who is supporting, listening and valuing you, is incredibly important. And for that, I will be forever grateful to Roger for really helping reinforce and build my confidence as a newly appointed judge. So I'm really looking forward to hearing what the other presenters' contributions, and I'm incredibly grateful for the presentation we've already had from Mr. Justice Mark Bishop. And I just want to end by saying thank you to Stephanie and her colleagues at UCLan for organising this event and giving us an opportunity to meet remotely, share our reflections on Roger and share our reflections on judicial leadership more widely. It's an incredibly important topic to discuss, and I just want to say thank you for that. And as I said, I'm looking forward to hearing the rest of the presentation. So thank you.
Thank you so much, Judge Brewer. Thank you so much, Michelle, for those simple words that actually put into perspective what we all have experienced with Roger, particularly in the field of equality, diversity, and inclusion, and pastoral care. Thank you so much. I'm sure we will discuss this further on in the Q&A session. And if those of you who were there at the beginning of the webinar have looked at the pictures I shared with you on the screen, you will have noticed the equality, diversity, and inclusion of those pictures. So I think that they are a testimonial to, to what we have all experienced. Now, let's welcome our next guest speaker, and we are particularly honored and thankful for his time and for the support of the judiciary of the Republic of Cyprus. So I would like to introduce the Honorable Judge Elias Georgiou, who is the president of the Assize Court in Limassol and has kindly agreed to share with us some of his thoughts and moments with Roger. I remember meeting you two over dinner and social events. So I think this is also another side of judicial leadership, which is very important. And that has to do with how committed Roger was to judicial dialogue with peers in the Republic of Cyprus. And for him, that was something that was very important. So, Judge Georgiou, thank you very much for being with us. And we are listening to you.
Can you hear me? And can you see me?
Yes, all good.
Okay. Director of the Judicial Training School of Cyprus, dear colleagues, distinguished guests, ladies and gentlemen. It is an honor and at the same time a privilege to provide a short tribute to the late Justice, the Honorable Roger Elsey. As the ancient philosopher Justinus stated, life does not take value from duration, but from honesty. And today we honor a decent, humane, courteous, thoughtful, open-minded, remarkable, reliable, and a steadfast pillar who significantly contributed to the preservation of the administration of justice. I met Roger after his appointment as a resident judge in Cyprus, and through our discussions in various matters, we built a close friendship. Over 2,400 years ago, the ancient Greek philosopher Socrates gave his description of the essential qualities of a good judge. He declared, 4 things must characterize a judge. Firstly, to hear courteously. Secondly, to answer wisely. Thirdly, to reason sensibly. And fourthly, to decide impartially. The late Justice possessed all these traits. Despite the fact that judges might come from different countries, different judicial systems, and different cultures, they share common values and principles which are part of a culturally specific heritage. Rule of law is considered part of the common heritage of European countries with political traditions and ideas as set out in the preamble to the European Convention on Human Rights. As you are aware, the term rule of law refers to the preeminence of the law over political decisions. The key principles thus include legality, legal certainty, preventing abuse of power, equality before the law, and access to justice. An efficient, impartial, and independent judiciary is the cornerstone of any functioning system of a democratic checks and balances. The rank of the European Convention on Human Rights within the national laws of the member states of the Council of Europe is important for judicial dialogue, and among others, can take place between judges in an informal way. Dialogues with Roger Elsey were always interesting and constructive. He was not only interested in learning about the Cypriot judicial system, but also enjoyed discussing the rights and freedoms as defined in the European Convention on Human Rights and how they are implemented at the national level. Furthermore, he liked conversing about the principles of subsidiarity and the positive and procedural obligations under the European Convention on Human Rights system. Also, we would discuss the doctrine of march of appreciation, which is applicable for non-absolute rights, and particularly to those rights where there is no European consensus and where the national authorities are best placed to assess and respond to the needs of the society. The late Honorable Judge Roger Elsey was fully committed to the rule of law, and we will remember him as a good person and as a decent, dedicated judge. May he rest in peace. Finally, I would like to congratulate the organizers of this event to honor the late Honorable Judge Roger Elsey. Thank you.
Thank you so much, Judge Georgiou, for sharing your thoughts with us, and particularly referring to these essential qualities of a good judge, which I think resonates quite well with what we know of Roger and what we have heard previously, including from Mr. Justice Mark Bishop. Particularly also this idea of balancing. You spoke about the margin of discretion, and I think this is probably something we can pick up in the Q&A session, because yes, that is very much the feeling we also had, that, you know, he was a very, very important, you know, example of balancing the quality of a good human being and of a leading judge. So thank you very much for this. Now, let me welcome our last speaker before we turn to the Q&A, where everyone is welcome to participate actively. And this is my colleague, Dr. Skliarchos Kyriakidis. I'm very happy to have Skliarchos with us. This webinar is as much his idea than my idea. So, you know, we share the privilege of having known Roger quite well and having enjoyed his company and his wisdom. Skliarchos was until last year the deputy head of the School of Law of UCLan Cyprus, and is now a senior visiting fellow at the School of Law UCLan Cyprus, as he has now relocated. And, you know, of course, the pandemic has somehow had some effect or impact on all of us. So this is the new reality. Skliarchos is going to talk to us about something which is of much importance to us, the academics, because we also have a duty towards the younger generation, as much as the judges have a duty to society. And Skliarchos will explore very briefly Roger Elsey's contribution to legal education as a paradigm of lasting value And I'm happy that we have now turned to the word value, because everything we have spoken about so far is value related. So Kleakos, we're listening to you. Thank you. We can see you and hear you. Everything is good.
Thank you very much for that warm introduction. I'd like to begin by thanking everybody who's been involved in organising today's event. And I also would like to thank all of the speakers. I extend an especially warm welcome to the members of the family of the late His Honour Judge Roger Elsey. I was privileged to know him only briefly, but in that brief time, he helped me personally in an exceptional way through his support for a number of the events that I helped to instigate or co-instigate in the School of Law at UCLan Cyprus. He was enthusiastic in his support for legal education and most willing to pass on his wisdom, experience, and what I would like to do over the next 5 minutes or so is articulate three pillars of what I would call the Elsey paradigm, which is very much a reflection of his conduct in relation to the university. But I would also make the point that it's also been over the last 20 years when I've been immersed in legal education. So the Elsey paradigm, as I would call it, has been applied in Cyprus by the late judge, but it's also been applied across the world by a number of other judges. But the way he did it was exceptional, and it was effective, and it was straightforward. So let me articulate each of those three pillars. First pillar is essentially a balancing act. What His Honour Judge Roger Elsey managed to do was the following. On the one hand, he projected the authority and the aura of a judge, and thus a member of the judiciary. He conducted himself, at least in his dealings with the university, in a way that maintained the dignity and the prestige of the judiciary. But at the same time, on the other side of the balancing act, what he managed to do was to be approachable and to remind everybody that he interacted with that as a judge, he was an integral part of the society of which he served. And that balancing act is absolutely critical in terms of ensuring that the judiciary maintains the respect that it must have from the public, but it also ensures that the judge is able to interact with society and is not a detached figure that operates in the shadows. Now that interlinks with the third point I'm going to make, which is about open justice and legal education, but I'll come to that later. Now, in that context, what I found most impressive was the ability of His Honour Judge Elsey to communicate effectively with students. He was conscious that in the Republic of Cyprus, where he was when he was teaching our students from time to time, he was dealing with a sovereign state that didn't have a university until 1990 or thereabouts, and didn't have a university law school until 2006, when the University of Cyprus opened its law school. We opened ours in 2012. So what he appreciated that he was stepping into an environment where we did not have a deep-rooted culture of legal education. Equally, he was conscious in his dealings with me personally that he was teaching students whose forebears, whose grandparents or great-grandparents would not have had the opportunity to go to university, either through the circumstances created by poverty or colonialism or any other potential explanation. So he was particularly keen to ensure that he could make a contribution to our universities, and indeed all of the universities' pioneering mission, which is to deliver higher education to students in a place where higher education was unknown for centuries. So that was the first thing that I wanted to bring across, this balancing act between maintaining the aura and authority of a judge, but on the other hand, being approachable and being able to communicate effectively with students in particular. The second pillar, which I want to focus on and articulate as being part of the Elsey paradigm, is that he appreciated a critical distinction. Mr. Justice Bishop has very kindly given us a public lecture in a public setting, which is being recorded, and it's excellent. It will have legs because it will be recorded and will be recycled for the future benefit of future students. But you will have noticed that in a public lecture, the speaker has to be very careful about every single word that slips out of the mouth. And that is because words are, as Lord Denning, the late Lord Denning once said, the tools of the trade of every lawyer. But it also is a consequence of the fact that if the wrong word slips out, controversy may follow. So what His Honour Judge Elsey appreciated was, yes, the public lecture is excellent. We have in England, and the UK, I should say now as a whole, a tradition of judge, and it's been picked up in Cyprus, I'm very pleased to see, of judges giving public lectures and having the transcripts of the lectures published to enable the lecture to have legs. So, for example, if you go onto the websites of both the Supreme Court of Cyprus and the Supreme Court of the United Kingdom, one can find the transcripts of judicial lectures. But again, the point I want to make is when you read those transcripts, they're exceptionally carefully worded. What His Honour Judge Elsey wanted to do, and he only managed to do this once because of the pandemic interfered and prevented him from doing it again, was to step into what I would call the coalface of the legal education system, to come into the classroom with a small group of students and to speak to them frankly, without breaching any confidence or breaching data protection or anything like that, but to speak frankly about the realities of practicing law as a barrister and then judging at magistrates court, magistrates court level and in the sovereign various areas court. Now, he didn't say things that were inappropriate or would have embarrassed him had they slipped out, but he was just much more frank with the students in the classroom setting. I went through my emails to find out the background to that event that he contributed to. He contributed to others, but this is the one that he would have been the model had the pandemic and the reactions to the pandemic not interfered. He agreed to come and speak to us on Tuesday, the 10th of March, 2020. That was one day before the World Health Organization recharacterized COVID-19 as a pandemic. And it was at a time when, if you recall, we were seeing all of these horrible images from Italy, Iran, and other parts of the world that were sending shivers down our collective spines, or some of our spines. He could have easily cried off and found an excuse not to attend, but he came to the lobby. He went through the procedures that were introduced at short notice. I was with a colleague and we were in charge of dispensing the liquids that had just been given to us and keeping the window open. But what the judge did was he came into the classroom with a pre-prepared set of slides that I didn't ask him to prepare, and he gave a 2-hour presentation based upon what the syllabus required. And what he did was he spoke about the magistrates court and its role in England and Wales in the first hour, and the county court and its role in England and Wales in the second hour. Now, I'm going to just emphasize this. There are plenty of judicial lectures on the role of the Supreme Court, its constitutional function, how it's been introduced in succession to the Appellate Committee of the House of Lords. You go to the website of the Supreme Court of the UK, you can find plenty of lectures on that subject. There are very few lectures on the Magistrates Court or the County Court. And he came into the classroom and he gave out first-year undergraduates a vivid, realistic, and educationally rewarding overview in the first hour of the magistrates court system, and in the second hour, the county court system. So the message I want to bring across is that every judge who wishes to engage in public education or supporting, let me rephrase that, every judge who wants to provide support to legal education should think carefully about whether they want to give a necessarily carefully worded public lecture in front of a public audience, which may involve journalists or others, or on the other hand, do they want to give a more frank presentation in a more intimate setting? So that's the second pillar, his appreciation of that distinction. But the third and final pillar that I want to refer to is his understanding that the courtroom is not just the place where justice is delivered, but a courtroom is an integral part of the legal education system. Now, many judges open their courts, well, they have to open their courts in line with the principle of open justice, but many judges ensure that their court is a welcoming environment for students generally, but law students in particular. We have, for example, in England and Wales, the community relations judges. And if you go to the website of the judiciary, I think it's judiciary.uk, one can find a list of community relations judges dotted around the country. But His Honour Judge Elsey brought that culture to the sovereign base areas courts, as he did his predecessors. Let me just stress that. But he brought that culture of having the courtroom as a place where students could be marshalled, that is to say, where students could shadow a judge, and also where students could come in and observe the hearings that were taking place. I cannot emphasize enough to law students that it's one thing reading heavyweight books or case reports, and another thing to actually step into a courtroom and observe advocacy in action, to observe a judge having to think and make difficult decisions on the spur of the moment or after considering submissions on a point of procedure, perhaps. But the other thing that's valuable about observing a courtroom in action live is that the student's able to understand the architecture of the courtroom and how that how the various parties, whether it's a criminal case or a civil case, fit into that architecture. So he made sure that his court was a place where students would feel welcome. So that, ladies and gentlemen, is really the Elsey paradigm and its three pillars, which I would suggest can be applied by any judge in any court, in any country, in any part of the world. And in saying that, I'm very pleased to see that on the list of attendees we have representatives from various parts of the Commonwealth, which share the common law tradition. I want to just finish with a personal thought, two personal thoughts, if I may, very briefly. His Honour Judge Elsey was very conscious that he was contributing to the promotion of legal education in a part of the world which has been blighted by conflict and inhumanity, and the application of what I would call force as distinct from the rule of law. And he was committed to ensuring that the inhumane consequences of conflict could be addressed, hence his support for the human trafficking research project at my university. So I want to thank my colleagues for ensuring that project has come to fruition, partly with the support of His Honour Judge Elsey, and in a sense that's one of his tangible legacies at the university. But the final thought is a very personal one. I know he was a man of the church. We did have some discussions, and it's a complete fluke that this memorial event was staged on the 29th of June. I understand it's the Greek Orthodox Christian feast day of St. Peter and St. Paul. And on that last time when I met him on the 10th of March, we traced the footsteps of St. Paul. And he was very conscious that St. Paul had walked across Cyprus along with St. Barnabas. And I think it's somewhat fitting that today's event is taken on that feast day. I close on that thought and thank everyone once again for participating today.
Thank you very much, Claire. Here, I think we both remember the same key dates. This is striking, isn't it? I also remember that he came one day before the official, declaration or announcement of the pandemic, and the official start of the lockdown in Cyprus. So he was effectively our last guest to university. And that was in itself courageous. If I remember well, he had just actually returned from Rome. You may remember that too. So he had just returned from Italy, and he could have chosen indeed not to bother and not to come, but he did. And he actually came prepared. And the 29th of June, how interesting what you actually said, since, as I also mentioned in the opening remarks, it's been today 1 year exactly that Roger last visited the university in person. I know, Claire, here you were away, but all of us were here. Michelle was here as well. And exactly 1 year later, unfortunately for circumstances we would all have preferred to avoid, we find ourselves again together to pay tribute to his legacy. So thank you so much. Now we have a good 30 minutes or even a bit more to discuss, to share thoughts. I know that there are many relatives of Roger in the webinar, but there are also peers and colleagues, whether colleagues from the bar, but also, of course, colleagues from the judiciary in England and Wales. And there are also peers from the judiciary in the Republic of Cyprus. So any thoughts, any anecdote, any memories you would like to share with us, please do so. This is, of course, recorded, but if there is anything that we would need to take out, we can always do that. This is not an issue. And then we can come back to the speakers, and particularly to Mr. Justice Mark Bishop's public lecture, which actually contains extremely interesting areas which we could expand on. But the floor is open. You may use the chat, or you may actually raise your hand, your virtual hand, and take the floor. So we are all eager to listen to anyone. Yes, so there is one comment in the chat. Thank you very much. This is from a family member. It's addressed to Claire Hos. Of course, I'm sure, Claire, here you could perhaps tease out the Elsey paradigm in the piece of work, in the written piece of work. And I would also like very much to welcome or to request, if possible, from our other speakers, if they could share with us their thoughts in writing, because, as Claire has said, it is in our tradition at the school to publish everything, particularly the public lecture. The keynote speech is of very much value to legal education, so we would welcome the possibility of publishing those freely online. Now, if there is no pressing question, I'd like to come back to one point which is very interesting, and it was raised by Mr. Justice Bishop. And it's interesting because actually, as I mentioned before, last week we were invited on radio here in Cyprus, on the RIG Classic Radio, to discuss the webinar by a local journalist. Her name is Saskia Constantinou, and she had actually taken the trouble of looking for some of the judgments delivered by Roger, and she had taken the trouble of actually reading the judgments. And she came up with some interesting thoughts, and she was asking about the role of judges in society. And in order to answer her very pertinent remarks, not being myself a criminal law expert, I actually used the exact same terminology as Mr. Justice Bishop's used before, and he spoke about some judicial courage. And this is a term that I actually used with respect to Judge Elsey during that interview, which is actually available online. of the courage that it takes and it took for Roger to actually decide specific criminal cases here in the SBAs, knowing the realities of society on the island of Cyprus and the difficulties that are inherent, particularly with criminal cases. And the journalist actually came back to, she remembered that actually, there were calls for overturning that specific decision. And of course, judicial leadership is first and foremost an exercise of judicial courage, sometimes also referred to as judicial activism, which was so well described in the keynote tonight. So I was wondering perhaps if all the judges, any of the judges we have in this virtual room, and we have quite a lot of judges in the virtual room, including very senior judges, if anyone would like to comment on what it is to have judicial courage, and if there is anything that you would like to share with the younger participants to this webinar, particularly the students. No particular pick, anyone can jump in. No? Okay. So perhaps we can keep this to later. Yes,
Stephanie, could I just say, I know I've spoken quite enough, and I'm not going to speak anymore. Someone else has got their hand up, I see. Let them speak. Somebody's got their hand up there, I see.
I think, Mark, we would like to listen to you a bit more, because you did give a very, very interesting keynote. So let's listen to Howard.
I was only going to give an example, really.
Yes.
From my, I never knew him, but Mr. Justice Ognall, and there may be, I think, Judge Brian Cummings is on this call, and will remember him being a judge from the north of England. But I remember he demonstrated enormous courage in a terrible murder case that was happened in the Old Bailey, Rachel Nickel, who was killed on Wimbledon Common. And the police had identified the defendant through really entrapment by having a female a policewoman befriending him and seeking to draw out from him about his sexual fantasies and engaging with and suggesting to him that it would help her if he had been involved in that murder. And they were seeking to draw an inference from his answers that he was the murderer. And Mr. Justice Ognall's is a case of enormous interest to the press, as you can imagine. And Mr. Justice Ognall said it was an abusive process. And he stopped the case before he on day one of the trial, he heard the abusive process argument and stopped the case and said it was an abusive process. And so it didn't proceed. That and of course, then, as we know, some years later, somebody else was prosecuted and convicted for that murder. So he was right to stand in the way, but he was subject to enormous public criticism by the press. I think he's died recently, and I think I remember him in his obituary reading about him saying that nothing. He wished somebody had actually. He never got the. He felt that all the opprobrium he got when he made that decision was not equal to the thanks that he got when he was proved to be right. I think that was the essence of what he was saying. But that was a very good example of a criminal judge being a roadblock to an injustice, really.
Thank you so much, Mark. This is very, very interesting. And yes, the roadblock to an injustice is obviously part of a judge's duties, but not only of everyone's duties. So thank you very much for sharing this example with us. I think Howard Elsey, who is a relative of Roger, would like to say a few words. The floor is yours, Howard, if you can unmute yourself.
Hello, can you hear me?
Yes, very well, thank you.
Okay, so on the subject of courage, Roger shared a number of stories which led me to the belief that in the courtroom, if it was written in a fiction novel, you wouldn't believe it. But particularly on the point of courage, there were things which I heard after he died, which showed particular courage before he died. And when working in Teesside, he was wanting to move more and more to family law. And there was a case which he was presiding over, and which he knew, or he felt he was coming to a decision which would see some children kept with their family when all the professionals were advocating that the children should be taken away. And he knew this was going to be a contentious decision. But speaking to his humanity that has been spoken to already, he felt that the worst thing that could happen for the longer benefit and good life of the children was for them to be taken away. And that is just one example, I think, which, particularly if there are law students listening, is a very practical example of also what's being said about how life in the courtroom is very different from one that you might imagine. And while I'm on, can I just say thank you very much for everyone who has spoken and for everybody who organised this great event. Thank you.
Thank you so much, Howard. May I ask you to set up your relationship with Roger, if you don't mind?
I'm his younger brother.
Thank you so much. It's a pleasure to listen to you.
Thank you.
Glakos has his hand up. And then, we also have a judge. So maybe, Clark, if you don't mind, we'll go to, yes, we'll go to the judge. So we've got Judge Amjad Nawaz. I'm sorry if I misspelled your name or mispronounced your name. The floor is yours. Thank you very much.
Good afternoon and good evening. You have pronounced my name correctly, and I'm grateful for it. I had to apologize earlier this week to counsel who'd been in front of me. I'd been mispronouncing his name for the whole week, and he was very courteous and didn't correct me, and should have done so. But Roger Elsey, I never met him, but I heard a good many fantastic things about him. And all I wish to say is that I'd like to express my condolences to his family, and their loss is very certainly our loss as well. But just getting back to your question as to judicial courage, in my perspective, it's a sense of doing what is right. That is judicial courage in simple terms, because the judge faced with the case in front of him or her will know what is right. And but that is intertwined by the comments and the lecture that Mr. Justice Bishop gave earlier, and that is to do with judicial independence, because we can only be emboldened if we are independent. And the two things cannot be divorced. They go glove in hand, or hand in glove rather. And if we try and separate them, we simply will devalue the mark. So I think judicial courage is about getting it right. And there are many examples. Judicial review is exactly that. It's being a buffer for the public, standing there. The judge is the last buffer for somebody who feels that they have not had justice from a government department and they have nowhere else to go. You are, as a judge, their final stop. And that's where judicial courage comes in. And we've seen it. Sometimes the decisions we make are not liked. And judges, as we've seen in the media dealing with the Brexit saga, where judges were termed enemies of the people. Now, and that's the backlash of exercising judicial courage. And we simply have to withstand it. And judges do that every day. And law students who come in and are going to start their careers as lawyers are just that as well. They are judges in waiting in that sense, because every day they carry out the same function. They carry out an analysis of their client's case and they do the best that they can for their client. So they are exercising that courage as well. And we all have to exercise that courage, because we all need to take courage from one another. So I hope that in my haphazard way helps in my assessment of what judicial courage is.
Thank you very much, Judge Nawaz, for sharing your thoughts with us. And I'd like to come back to judicial independence, but let's give the floor to Claire Hoss first, who had his hands up, and then we can continue the conversation.
Thank you. Can you hear me? Yes. 3 comments. As a follow-up to what's just been said, students are judges in waiting. I think that's a telling comment. That is something that's influenced me over the years. I'm very conscious that when I've been teaching a lot of students, whether they're first-year undergraduates or postgraduate legal practice course students, as I used to teach in England, or master's students, I'm teaching human beings who, by and large, aspire to enter the legal profession as practicing barristers, solicitors, or other members of the profession, depending on where in the world they will end up. But if they go into the legal profession, and over the years, my colleagues and I have tried to instill in our students the concept of moral courage, as well as physical courage. But moral courage is the key criterion here. And as we were having this discussion over the last 2 or 3 minutes, I just found on the internet the original flyer for our event on ethics on the 21st of November 2019. His Honour Judge Elsey was not listed as a speaker, but he came along, if Stephanie will recall, he sat in the back of the courtroom, moot courtroom, and gave an off-the-cuff lecture, which helped to instill in our students the importance of moral courage. And if I remember, that event was partly intended to prepare our students for the real world, where they might go into a law office. Hopefully they wouldn't, but they might go into a law office or other working environment where they are placed under one form of improper pressure or another to do one improper thing or another. And in Cyprus in particular, and other parts of the Eastern Mediterranean, there is a tendency to apply pressure in untoward ways. And His Honour Judge Elsey was like a duck to water. He came into that moot courtroom and addressed the ethical and practical issues of dealing with ethical dilemmas in legal practice with aplomb. So that's the first thing. The second thing, very briefly, Mr. Justice Bishop earlier spoke about the great Lord Atkin and the Liversidge and Anderson case. I encourage everybody to read the biography of Lewis. It was originally published by Butterworths in 1983 and republished by Hart in Oxford in 1999. There's a chapter in there on the behind-the-scenes pressure that was applied to Lord Atkin, which Lord Atkin robustly resisted, and it's a model of judicial independence in practice, but it's also an example of judicial courage in practice. Thank you.
And it's also interesting to know Lord Atkin, he was born in Australia, of course, although his career was in England, and grew up in Wales later, or had links with Wales. But he was basically, his parents were in Australia. And he was born in Australia, so I always think of him as, you know, a great Commonwealth contribution really to the development of common law at that time. And I wonder if he would have had those robust insights if he hadn't been, in some ways, a slight standing slightly apart from the society in some way. I don't know. I don't know enough about Lord Atkin to make a judgment about that, but I'm interested by the pressure he was under, and the tone of the judgment. And, you know, quoting Alice in Wonderland in the House of Lords in 1942 is just extraordinary, absolutely excoriating his colleagues, and very, very remarkable man, I think.
Remember, Churchill would attend Parliament throughout the Second World
Yes.
War and face difficult questions and answer them to the best of his ability. And Lord Atkin and Winston Churchill, in their own different ways, demonstrated what the Second World War was about. It was about fundamental principles against tyranny. And of course, as we teach the students, wherever law ends, tyranny begins. Locke, I think, if I remember correctly.
So,
Thank you very much, both. Actually, Claire, here the ethics day event you mentioned is one of the pictures I shared at the very beginning, where Roger stands in the middle, you know, of the moot court room with all of us, and this is a very fond memory. There is a very nice comment in the chat from His Honor Judge Stephen Earle, and I'm wondering whether you would like to say it or whether you would like me to read it out. I'm happy to read it out if that is best. Okay, so I'm going to read it out. And it says, Roger is by far the judge I have learned the most from. So again, we find someone else with the same approach as Judge Brewer. We were sworn in as judges together in the magistrates' courts in Teesside 18 years ago, last month. And I had the privilege of seeing the force that he was sustained by Sue and the girls, and taking on so many tasks, including establishing the community court, which we also referred to before. We both moved to Northumbria in 2008 and led the judicial meetings in that area with such skill and diplomacy. He will be sorely missed by all who have had the benefit of appearing with and in front of him. It is such testimonial that you have held this event today, and truly, just a second, sorry, I have an email that appeared and I missed the line, and fully deserved. Thank you very much, Judge Earle. Thank you for this testimonial, and this is exactly why we're here now, to listen to testimonial and share thoughts with each other. I'm looking at, I think, yes, there is one more hand up, and this is from a colleague of ours, but she appears to have disappeared again. Nevi, did you ask for the floor?
Yes, please.
If I can just introduce you. So Dr. Nevi Agapiyu, she's a colleague at the school. Nevi specializes in international commercial law, but also dispute resolution. Nevi, the floor is yours. Thank you.
Thank you. I just wanted to echo what you said, but also what Claire has explained. As an academic teaching in the school, primarily teaching skills to our students, we're fortunate that our LLB incorporates basic skills such as advocacy. So the interaction with an active judge is most invaluable, not only for the students, but for us academics. We also learn, we live to learn. So it's always very nice and rewarding to see our students perform after having been trained by us before a judge, and they also receive tangible, constructive and invaluable feedback by a practicing judge. So I'm most thankful for the interaction and his contribution and help and support to academics, but also our students. And I'm thoroughly enjoying this event and recounting the moments that I've had to interact with the judge myself. Thank you.
Thank you very much, Nevi, for one more testimonial. Until we get someone else who is brave enough to take the floor, we do have someone. Yes, His Honor, Judge Brian Cummings.
yeah.
Am I right?
Hello, yes, you are.
Yes.
Can everyone hear me?
Yes, we can. Thank you very much.
Just having problems with my camera, so if no one minds, I'll just speak. I just wanted to start by saying, of course, how offended I was by Mr. Justice Bishop's suggestion that I might have known Mr. Justice Ognall, merely because we're both from the north. Of course, I'm far too young for that, as he well knows. just a few words, if I may, about Roger. I didn't know him well. What was it? Sorry, I've touched my mic. I didn't know him well, I'm afraid. I had the pleasure of meeting him twice. Once when I first went out to Cyprus in summer 2019, and then on a subsequent occasion in October 2020. And of course, I hoped there would be other occasions. And sadly, of course, that won't be the position. And I, like others, extend my condolences to his family. So this is really just a short recollection. It's no more than that. But I had actually heard of Roger before I met him, simply because a friend of mine, an old university friend, was at the bar in Newcastle. And of course, as many lawyers and judges will appreciate, the law really is a village. So in that way, I'd heard of him, and what a nice person he was. And very simply, that was my experience. He was very decent, welcoming, warm-hearted person. Had a wonderful evening. The first occasion I met him, together with Mr. Justice Bishop and another of our colleagues now retired. We were sitting, in fact, in the Eastern Sovereign Base area, but travelled over to spend a very nice evening with Roger. And then the second occasion, which was October 2020, I was over on my own and found myself with a little spare time at the end of the trip, and was able again to travel over and see him. And of course, it was another wonderful occasion, and he showed me around, very knowledgeable on the sovereign base areas and really everything to do with Cyprus. And that was one of the things that struck me about him, really, that he was interested in everything. He was interested in the law, he was interested in the courts in Cyprus and, of course, in the UK. He was interested in the island itself and the people and the history. He was interested in the language. I know he was working on his language skills, and I saw him deploying them to good effect in restaurants and the like. And he spoke about his connections with the university, and very enthusiastically and warmly, as with all topics. And I just make the observation, really, that in addition, of course, to all of that making for a very good host and friend, I think it also contributes to being a good lawyer and a good judge, because the law and court work doesn't exist in a vacuum. We deal with real people, and against the backdrop of life as a whole in all its color and complexity. And the better that one can understand life, the more that one can be interested in life and people, and have that broad backdrop, so to speak, to bring to professional practice, the more it makes for an effective lawyer and communicator, and of course, in the context of the judiciary, a good judge. So everything I've heard about him tonight from others, expressed most warmly, is entirely in keeping with my own sadly limited experience of the man. He's a great loss, both on a personal level to anyone who had the privilege of knowing him, but also plainly on a professional level to the law and the courts. So this is a wonderful evening and a wonderful tribute to him. I'm glad to be present to observe it all, and I extend my thanks to all who have spoken.
Thank you so much, Judge Cummings. It's a pleasure to meet you, for all of us.
Sorry about the camera.
And never mind, perhaps we'll have a chance when you next visit the island for you also to visit the campus.
Thank you, and I love that. And actually, just talking or mentioning that, it's something that I know Mr. Justice Bishop has spoken about. And I mean, speaking personally, I couldn't hope to emulate Roger in the way that Mr. Kyriakides described his wonderful attendance and the way he dealt with students. But it would be a great pleasure, I'm sure, for all of us to do what we can, perhaps on occasions when we're over on the island anyway with other work, to make a contribution. Can't tell you anything about the county court, I'm afraid, but I could talk about the Crown Court.
Thank you very much. Yes, that would be lovely indeed. In fact, we were very privileged not long ago to welcome Mr. Justice Bishop to campus, and I must say, he deployed so much patience and sat and listened to us. So he was a very active listener to listen to everything we had to tell him and all the good research we do, and he was so supportive. So yes, we are very grateful to any member of the judiciary or indeed of the legal profession from the Republic of Cyprus, England and Wales or elsewhere who passes by the campus and actually tries, and gives time to the students and to the academics. This is extremely helpful for all of us. Now, there is a person who would like to talk, and I'm afraid I can't actually say the name because I can't see the name. So the person who has raised her hand or his hand, you are welcome to take the floor now, if you know who I mean.
I think that's me. Hello.
Yes, that's you. Thank you.
Hi. I'm Georgina. I'm Roger's niece. So Howard's daughter who spoke earlier. And I wanted to just testify a little bit because obviously I didn't know Roger professionally. It's been such a privilege to be able to hear about people's experience of him, and the way that he has such an impact is so wonderful to hear. But what I wanted to say was that I recognize who you're talking about. So even though I didn't know him as a professional and I didn't know him from his sort of the perspective of being a judge, it is, I think, something to who he was that I still recognize who you're talking about. And the reason that came to mind is when you were talking about courage and judicial courage and moral courage. I think that's, and especially what Judge Cummings was saying about the almost the holistic nature of what it means to have a public role. And as you can see, I'm a priest, so I sort of have a crossover there in what that means. That holistic feeling of what it means to be good at your job in that role shows integrity. I think something that I'm really recognizing in this evening that, I would have said about Roger anyway, but as obviously across the board in his life, from a family perspective and also from a professional one, is that the importance of integrity, that how good you are and how courageous you are or moral you are in one area of your life, it has to be across the board. It cannot be, you cannot as a person sort of have those different different ways of being. Like the integrity across who you are is, I think, part of what made Roger quite such a good example, that he was better for everything that everyone's saying about him in that area because he was like that across his life. So I think that speaks to something else that I recognize in him, which was the idea of vocation. I think the idea of law as an area, like you say, it's a village, but I think that's because there's an element of you're all there not just because it's your job, and I obviously I'm kind of guessing a little bit there, but I wouldn't be surprised, especially the small interactions I've had with people in the law, that I don't think certainly Roger felt like it was just his job, that it was important to him as a person and what he was doing and wanting to be right and good at it was a vocation. And he would also, I think, want to point away from himself a lot and say that he's learned a lot himself. And I'm really glad someone mentioned, I've got a bias, someone mentioned St. Paul, but Roger was a man of the church, and I think obviously there are religious examples like someone like St. Paul that he would point to, but also I'm sure plenty others. And I'd be very surprised if they were just other judges that he admired, or even other sort of religious things. He probably had a lot of people across a spectrum of areas that he pulled from as examples into that holistic understanding that he would have, I think, wanted people to follow his example amongst many, because that's the sort of person that he was, that he admired things in others that he would want to integrate into himself. Thank you.
Thank you so much for this testimonial. That is exactly what we were hoping for tonight, especially from younger people, relatives, and of course, persons from other professions. And that is we are most grateful. Thank you so much. I see now there is someone else with the camera on. That's Janine Elsey. Good evening.
Good evening. It's actually Sue, Roger's wife.
It's Sue.
Yes.
Good evening, Sue. Thank you so much for talking to us.
Well, it's just been an absolute delight to hear all this, the wonderful things you've said about Roger. And I would just like to finish from a family point of view, is that sometimes we wondered whether the decision to go to Cyprus was the right one for us as a family, certainly with the pandemic in mind. And I just want to say to you all, it was absolutely the right decision. He went there and he loved it. It was something he was desperate to do. It was how he wanted to finish his work. It finished earlier than any of us could have imagined. And I think we all feel that pain today and will for some time. So I just want to thank everybody who's contributed to this. And I know he would have been absolutely thrilled at it and what's been said about his work. And from the whole of the family, I'd just like to thank you all from the bottom of our hearts. Thank you.
Thank you so much, Mrs. Elsey. Sue, I do remember you from, of course, the memorial service that was held in Limassol that day. And happy to see the baby as well, who's grown up. And Janine, yes, I remember the baby at the memorial service, just a few months old.
He brings a lot of joy.
Who will miss his grandfather dearly, unfortunately. I think we have come to the end of this webinar, which I think is exactly as we wanted it to be. So I'm so grateful to everyone. I would like, however, to perhaps give the floor, if he wants it, to someone who has been listening very patiently since the beginning. It's the director of the Judges School in the Republic of Cyprus, Mr. Justice George Rotokritou. I was wondering whether you would like to say a few words about everything you've heard, perhaps, or anything.
Yes, thank you, Stephanie. I had a few problems joining tonight, and I'm joining from my mobile. I'm very grateful to Michelle Brewer, whom I see now. Her camera is on, for introducing me to Roger. It was a very brief encounter. We went out one evening on Michelle's suggestion, and we arranged to meet a few months later on, but unfortunately we were not able. I was very sorry to hear the news, and I couldn't even attend the funeral because there were no news. I remember I wrote to Michelle, but at that time, a few days after the event, she didn't even know. She didn't know herself. But anyway, I have fond memories, although our encounter was very short. And I apologize to you, Stephanie, when you asked me to speak, that I politely declined, but I suggested my colleague Elias, who had a longer encounter with him. And one thing that I want to say is that I always wonder why good people leave us much earlier. Because the last year I had at least two of my two good friends and who had a lot to give to society that passed away much earlier. And I often think why good people don't stay with us longer and they go away all of a sudden. Sometimes I think there must be a reason. Sometimes I think they are wanted somewhere else. But anyway, congratulations to you for organizing this excellent event tonight, and my condolences to Roger's family. And thank you, Brewer, Michelle, for introducing me to Roger.
Thank you so much, Mr. Justice Rotokritu. Michelle, if you would like to add something, and I would like to ask Antonis to switch off his camera, please.
Thank you very much. I remember fondly that I had the pleasure of having both George Erotokritu, a very, very senior Cypriot judge, former Supreme Court Justice, and Roger at dinner. And I suppose that really takes me, as a newly appointed judge, we talk about judicial independence, judicial integrity. And although I was at the bar, nothing really can prepare you for what it's like to become a judge. Nothing can really prepare you for what can sometimes be a lonely job, and why our judicial community, not just domestically, but globally, is so important for us, and why relationships such as that I formed with Roger, but also with George and some of his colleagues in Cyprus, is so pivotal for junior judges like myself. And so to have the dinner with George and Roger was really good for me as a junior judge, to just listen and listen to the wisdom that was being shared, very humbly, but still being shared. And so I'm very grateful for that. And again, you know, we're very lucky, I have to say, in our judiciary for having some really wonderful leadership judges. And it's just sad that we've lost one of those in Roger. But thank you again, Stephanie, for this. It's a really important event.
Thank you so much, Michelle. I would like to give the floor to Mr. Justice Bishop for the last few words, and then we will bid farewell to everyone.
Well, I think I would like to join in all those expressions of solidarity, if that's the right word, with Roger's family at this time. We all miss him a great deal, and of course nobody will miss him more than his family, and we all know that. But we would like to share with you our high esteem, the high esteem with which he was in our view, and so that all that he did in the SBA and in Cyprus is known to the family as much as it is to us. And I'd like to just say that I think this is a very important contact and communication between the judges that come out from England to do this work in the SBA. We get a very high quality, I think, of advocates, particularly young advocates, who appear in great courtesy, speaking in a language that is not their own in courts in the SBA. I think we all should pay tribute to that, and it's a very good experience for all of the judges that come out to the SBA. And I do feel every time I come and do a case and hear the advocates from the Republic making their submissions, citing all these authorities, that we are all, well, in the words of Lord Bingham, we're all guardians of that all but sacred flame. We're all serving the same purpose. And this today and this for this year, I think it's particularly important that we reinforce what we stand for and what we're opposed to. when we see the world not that far away from the Republic, in Ukraine and elsewhere, where the rule of law is not respected. So we stand together on that, I think.
Thank you so much, Mr. Justice Bishop, for those last words. It's 8 o'clock Cyprus time, exactly 6 p.m. In the UK. I would like to thank everyone deeply. We are very grateful for the time that all of you have devoted to us, and we're very grateful to Roger's family for having actually embraced that idea, that initiative, and supported us and shared with us some anecdotes and memories. And as a tribute to his legacy, we will have this video, which we will be able to edit thanks to our colleagues at the university. Thank you, Kostas. And make available publicly so that anyone can then cherish those moments, hoping that would be our way of helping the family to deal with the aftermath of his death. So we are once again very happy, and we couldn't hope for a better outcome of this event. So thank you, everyone, and thank you for joining us. And it was very nice seeing many new people, including judges, but not only. So thank you, everyone, and hoping to see you soon again, virtually or in person.
Indeed. Thank you.
Bye, everyone.
Bye. Goodbye.